Thank you, Susan, and welcome everyone to the Forum on Law, Culture, and Society at NYU Law School, coming to you live at the 92nd Street Y. This is, in fact, a new program of ours, and we are planning on this being an annual one right after July 4th. Hopefully next year it won't be nearly this hot, but we'll be back here again to do the very same thing. When hopefully we'll bring back our NYU team, and some of our broadcasts media journalists will rotate over the years. We just passed the July 4th holiday, which means that as a nation we commemorate our founding and our democracy and our institutions. And the Supreme Court is one of those institutions that everyone knows, but no one really seems to understand. It's opaque, it's mysterious, the oral arguments look like Talmud classes, mind-bending Talmud classes, and it's even worse than that. You know, the language is not familiar. We're going to hopefully talk a little about that. Years ago when we had Supreme Court Justice Sotomayor on our stage here, I asked her about this. She initially had been in favor of cameras at the Supreme Court, and she changed her mind, and she had a very interesting thing to say about why she doesn't think the public should actually watch the Supreme Court in action. But never fail, the Forum on Law, Culture, and Society folks, we're here to provide a civics lesson every year this time, where you'll learn everything about the term, the Supreme Court that we've just had, and also in this year with Justice Scalia's death, the politics of the Supreme Court. We are here with an incredibly esteemed group of conversationalists. We're missing one of our guests, Dahlia Lithwick, who is a longtime friend of folks. This would have been her third appearance with us. She's on a plane. She may be here. At some point, a chair will appear, and she'll sit down. Greet her warmly, because it's hot. She's probably frantic right now. But we have some incredible people here. First, everyone knows this is her first time as a guest, but Nina knows that I've been for years wanting her to be a guest at Folks. She is the voice of NPR's Legal Affairs Matters, everything having to do with the law, Nina Totenberg. And on the very opposite side, anchoring the other side, is my good friend from the New York Times. Adam actually has been, this is his third time as a guest here at Folks. He is presently the Supreme Court reporter for the New York Times. Before that, he was the national legal affairs correspondent for the New York Times, and his parents are here. So please, really, so cheer for Adam Liptak. Yeah.
We mustn't be mean. Nobody be mean to Adam.
That's right. Give Adam a break. That gentleman over there is Kenji Yoshino. The next two of our guests are actually colleagues of mine. This is the NYU team. Both are distinguished constitutional law professors. Kenji, you may know, if you came to our Trials and Errors event last year, we focused on his book, Speak Now, which was an incredible book about Proposition 8 and the Hollingsworth case. And we had Kenji, actually we had Dahlia, but we also had Deborah Messing, and Kenji liked that. That was cool. Kenji took lots of photos after. You may have seen him before. He appears frequently on Rachel Maddow's show on CSNBC. And you may not know this, but if you read the New York Times Magazine, he is the ethicist for the New York Times, Kenji Yoshino. And finally, this handsome man is also a distinguished constitutional law scholar. He worked for a while in President Obama's Office of Legal Counsel, so there's a very different perspective that we'll be able to get. He's widely published as an academic, and he is the dean of NYU School of Law, Trevor Morrison. Now, by now you've probably figured out, since I'm also at NYU, that I sort of work for that man.
I think it's the other way around.
Don't be mean to him either.
So if anyone in the room, and this is up to you, if anyone hears anything I say that's even remotely intelligent tonight, it would not be terrible if there was an outburst. Genius, brilliant, who is that guy? Harvard is going to get him, something like that. You heard Susan Engel say that audience participation is encouraged, and that's how I would like you to participate. Is he laughing? Let's start with Nina. Nina, oh, I just took your water, Nina. So sorry.
That's not nice.
Tell us what makes a great term for the Supreme Court? Do you need to have blockbuster cases? Is it little like, soccer seems to me to be a strange sport. It seems simple, but yet there's all these nuances within it. So the score could be 1-0, but people who know the game know a lot's going on. And I think maybe, is it possible that these decisions could be made in very gradual, incremental, narrow ways, and people who track the court could go, that was a great year, even if no one can remember the name of a case, and there's no Roe v. Wade, there's no Brown versus Board of Education.
Not us.
Right.
Not Adam and me. No. The answer is no. You need the court to either move in a very steady direction that you can see and you could track and you could follow what it's doing, or it's better yet if there are blockbusters. And in the world we live in, where actually lawyers for special organizations like the NAACP or the LGBT community or whatever, they don't control the litigation anymore. There was a time when Thurgood Marshall took the cases that led to Brown versus the board over, 15 years, something like that, where he really was the puppet master. He controlled which cases they were appealing to the court and when and how, and it was when we say he was the architect of the battle for civil rights, we are correct. And when we say that Ruth Bader Ginsburg was the architect of the battle for women's rights, we are correct. But we don't live in that world any more than there are 3 TV networks. Mm-hmm. It's just different. And so the LGBT community, the sort of leaders of the legal movement, by and large, did not want to move as quickly as Ted Olson and David Boies wanted to move. And guess what? They turned out to be wrong, and Ted and David were right, but that doesn't necessarily happen. You can also land on your posterior. So the short answer is no. A great term is a term with blockbuster cases. I suppose a great term for news reporters is a term where there's a sudden and unexpected vacancy on the court. However, it is not a great term when you have to listen to the people in oral argument without that individual who was the spark that lit everybody else's fire. And without him, it's a much paler place to cover.
Well, this is a good moment for Adam Liptak, because I think we had thought that there might have even been up to 6 blockbusters this year. So I don't know with Scalia's demise, whether because of the demise, we end up with no blockbusters. And so tell us a little about, because you've written about this recently, about the continuing dynamics of the court when you only have 8 justices. Before we talk about any specific cases, let's talk more broadly about the environment in which we're looking. And we're getting ties. We're getting 4-4 ties. Most people in the room doesn't know what happens when you get a tie. So help us understand how much was the court compromised in the last 4 or 5 months with the death?
What a great question. Is that Harvard calling?
Yeah.
I'm laughing.
He's laughing, and that's how it's done, all right? So now you saw the bar.
I think it was Justice Byron White who said every time a new justice joins the Supreme Court, it's a different court. What we've learned this term is if you subtract a justice from the court, it's a different court. So an 8-member court, obviously, even numbers not ideal for appellate court panels. And what you would expect, we got some of, which is a 4-4 ties. They deadlock, they issue no decision, they set no precedent, they don't disclose the votes, and they leave in place a lower court ruling, which can be consequential, but it's not what you want from a court.
Do they issue an opinion?
No, they issue 9 words. The judgment below is affirmed by an equally divided court. So not very satisfactory. Not a lot to write about, actually, beyond the bottom line. In other cases, it turns out an 8-member court can try very hard to decide something, but that something can be so narrow and so muddled that it's also quite unsatisfying. So that's how most of the potential blockbusters washed out. Two big exceptions, both of them, and this tells you something about the dynamic on the current court. On the old 9-member court, Justice Kennedy was very much the central figure. He still remains in the middle of the court, but the middle of the court has gotten a little broader. Chief Justice Roberts, Justices Kagan and Breyer are also playing a role. And you can see permutations of those folks. Anyway, the bottom line is when Kennedy did join the liberals in the two big decisions they actually decided on affirmative action and abortion, we got actual and consequential big decisions.
Now, this is for all four of you to some degree because you've been court watchers in your respective fields. Scalia was widely known as the one who spoke the most, was the most active in oral arguments, during oral arguments. He was also known as the funniest. He was known
and the best writer.
And is that also the best writer?
Yeah, I think in any sense of writing as a craft, I'm not talking the best writer of a legal opinion per se, but writing as a craft, vivid language, incredibly wonderful allusions and things like that, and being funny even in your writing. I think he would have qualified as the
So
best
the life
writer.
of the journalist got harder with Scalia's death because
Yeah.
there was always something quotable in argument. There was always something quotable in his opinions, and you don't necessarily get that from some of the other justices.
Well, that was one of the things I was going to say. Does it appear that anyone is angling to fill those spots? Someone who is now more active in oral arguments, someone who's funnier than the others. It's people who before felt a little reserved because his shadow was so great, and that perhaps now they feel, I've been on the court for a few years, now it's my turn.
Alito. Alito would like to be that dissenter in those big cases, but having sat through all 17 minutes of his dissent in the affirmative action case, not happening.
Trevor?
I'm not sure I fully agree with obviously the best writer, even while he was there. Clearly a very good writer, a very colorful writer, a very memorable one. I think Justice Kagan was well on her way to establishing herself as
I agree.
in a similar category. And as for most active questioner, I believe that this is right, that even before he passed, Justice Scalia was not in the lead as having asked the most questions this term.
No, I think he had most, but not most words.
Okay.
Yeah, he had most. Sotomayor
They
was-
track this sort of thing.
So, the basic point being that since she joined the court, Justice Sotomayor has been an exceptionally active questioner, roughly in the league, whether or not literally.
And she's really filling the void
Yeah.
to a very great extent of Justice Scalia's absence. And it's sometimes forceful, but it's less light on its feet.
Well,
Justice Kagan was at the law school a few months ago, only about maybe a month and a half or 2 months after Justice Scalia passed, and she said something interesting in a conversation that we had in front of a big group of students, that she thought that all 8 of them were in one way or another trying to take some step to compensate for the loss, and whether in oral argument or otherwise. And I'm not sure whether Nina or Adam.
It was actually a very touching moment where Justice Thomas stepped in, right, and spoke up. He was famously silent and asked no questions generally during oral argument, but after Justice Scalia's passing, he actually came in and asked a question relating to the Second Amendment, which is a cause near and dear to his heart. And so there was this notion of, was he going to actually break the silence and continue? But it seemed like it was.
Was it your sense, Kenji, that he broke the silence in the spirit of Scalia's absence? Or, because, prior to that, I don't think he spoke
10
since,
years.
Virginia versus Black.
Exactly, yeah.
No, no.
What was
Yeah.
that?
So I mean, it's always, just speculation, but there was a sense of the timing that made me feel like he was carrying a torch on behalf of his beloved.
So there was
colleague. Yeah.
that example of Kagan and Thomas are 2 examples of 2 justices on opposite sides that showed that level of collegiality that they entered in.
Kagan is probably most like Scalia. Of all the questioners, I think, she can be quite funny, but she's sort of was the counter to him on the liberal side. She would ask very clever, intelligent questions, and she was incredibly well versed in all the facts. And her hypotheticals, were very challenging from the liberal perspective most of the time. And I would have to say that Alito's hypotheticals are enormously challenging. When I say the 17 minutes of the opinion, that's one thing, but he is a fiercely intelligent questioner from the right.
And there's a point to be made about oral arguments that may not be obvious, which is it takes the form of a question and an answer, but it's really not there to elicit information from the advocate. The advocate is basically a bystander. It's the first opportunity the justices have to talk to each other about the case. And so Kagan, as the junior justice who votes last at the private, at the private conference, really has to take this opportunity at the argument to make her points and to try to shape the decision and its rationale.
Can I just say something about Justice Scalia? I mean, I don't want to at all speak ill of the dead, and he obviously is an incredibly, he's a luminary in the law and is a major figure in American law and will always be regarded as such. But I have to say that with regard to style and tone, I want to separate out the kind of entertainment value or the newsworthy value, not to diminish that, from the kind of negative model that he set for, say, many of our students, right, who are reading his opinions and who revere him as a writer. But oftentimes the kind of zingers he would let loose either against the parties or against his colleagues were not something I want my students to emulate. No, the law is a very serious business. It has real violent consequences on the people before it. And so either to let loose on the parties or to make a humorous point about something that isn't particularly light matter, or alternatively to say to a colleague of yours that her opinion diminishes the Supreme Court is a really serious thing.
So you're saying it was lacking in sensitivity and collegiality. You don't mean that some of the language was, say, politically incorrect.
No, I guess what I'm trying to say is among Scalia clerks, I think that there was a competition of who would pick up zingers. The clerks would loft up to him, right, and his opinion.
In all fairness, he was on the court for what, 28 years? I think it was 28 years. And I knew him long before he was on the court, and I knew him in the first years, in the middle period. I'm much older than all these other people. I just started when I was an infant. And I was on a panel last week with Larry Lessig, who was his law clerk, who made a point that I think that really resonated with me, which is that there are different Scalias. The first 10 years of Scalia and the second 10 years and probably the last 8 or even 5 they're very different kinds of people. And by the time he was in his last years, he knew what he thought. He was somewhat peremptory about it. There are people who thought that he really didn't even work as hard as he had before, although God knows he worked hard. You don't write like that and not work hard. And he had plenty of critics who said that he was too negative in those last years and the kinds of things that he wrote, especially in the cases involving gay rights and then later gay marriage. But if you go back and you look at the earlier Scalia, and not even that much earlier, 10 years earlier, it's sort of a different tone. And sometimes a tone for the worse, I suspect. I mean, you read his dissent in the first big gay rights case after the liberalized rules, which was a case called Romer. And it accuses the majority of taking sides in the culture wars, et cetera, et cetera. In those words precisely. And by the end, his last opinion was very rough on his colleague Justice Kennedy, but it did not have those politically incendiary comments. It softened it a bit. So he's a complex person.
Is Romer what you were saying? Was that one of the cases you were thinking of?
Actually,
Obergefell.
But
Yeah,
Yeah,
you were thinking of the last one.
No, actually, I wasn't thinking of either of them. I was actually thinking of comments that he made towards Justice Sotomayor in a criminal procedure case. But with regard to the gay rights cases, I mean, I think that we have to be careful there because there are alternative explanations. One of our graduates, Ian Samuels, clerked for Justice Scalia and wrote an essay, preserving the kind of cloak of silence that clerks are supposed to preserve, but appropriately observing that a counter clerk can present a really interesting role. So he clerked for Scalia during the Obergefell decision, which was the same-sex marriage decision, and he wrote that one of his other members of the clerk family for Scalia, who was actually clerk for my judge, Gil Seinfeld, was clerking for him during the Lawrence years, and Lawrence versus Texas was the opinion that struck down sodomy statutes across the United States. And Gil said he wasn't going to have any part of Justice Scalia's dissent. So he said, I'm going to opt out, because Scalia had a tradition of hiring counter clerks who are more liberal rather than conservative, so that he could use them as a sounding board to make his opinion stronger, which I think is a really excellent aspect of his nature and his personality. But the thing that Ian says is that in contrast to Gil, he as a counter clerk did not opt out. And that he actually wanted to participate and may have softened the Obergefell decision. So that could be about the contingency of a clerk.
That's sort of the subject of the play about
Yes.
Scalia. That's sort of the idea in The Originalist, that the counter clerk, in this case, who's a black female lesbian, manages to persuade him to soften a few things in the opinion.
Right. Yeah.
The only thing she's not is a nun.
One must remark that if the Obergefell dissent that saw the light of day was a softened version of the original,
I'm
must have
wondering,
been something.
Adam and Trevor, given the fact that you both raised Sotomayor and Kagan, are you of the view that either now, because we only have 8, or even when we get 9, it's likely that it's possible that Kagan or Sotomayor might become the Kennedy swing vote, or might exert the kind of influence that was lacking? I mean, what are you really betting on when you're saying that we're seeing a different side to them? Are they going to take a leadership position? Are they going to end up as a swing vote? What's your thinking on
I
it?
think Sotomayor is drifting left and is more apt to be a kind of moral crusader dissenter. Kagan is terribly strategic, very much wants to be in the middle, very much wants to have an influence on how the court is shaped. I think wouldn't mind being Chief Justice, and this term she was in the majority, almost as high as Kennedy. So I think a lot of people have high hopes for Elena Kagan.
And so is Brian.
Trevor,
They were the critical 3.
Trevor, is that also what your thoughts are about Kagan?
That sounds about right. I'm not betting on it. My father-in-law is here, and ever since I told him that there was no way the court was going to take Bush versus Gore, I'm out of the, I'm out of the betting business. But I don't know about Justice Kagan's aspirations to Chief Justiceship, but I think that she seems interested in, and has proven some effectiveness at, coalition building in ways that can spark comparison to the current chief. And I think some of that has also maybe involved a kind of tactical thinking about the precise ground to base an opinion upon. And Justice Sotomayor, I think, has been most distinctive when she's staked out positions that are definitely the expression of exactly what she thinks is right, perhaps even if they came at the expense of a vote.
But let's be really clear that the center of the court is not going to be either Kagan or Sotomayor,
Yeah,
right? It's
Not in the near term, anyway.
Right. The
But will it
replacement-
continue to be Kennedy in the near term?
No, I think it's going to be Justice Garland if he's confirmed, or it's going to be Justice Breyer, right? So that's
right.
going to be the new
And
center of the
Breyer's
court, and that's a totally different court,
Yeah.
to Adam's point. In fact, I have never, been, in the law without having a conservative court. So, I mean, my title is Earl Warren Professor of Constitutional Law, right? But it used to be that if you were a liberal, as I am, you could just walk into court. My colleague Bert Newborn always says, you could sneeze on a paper and win your case. That you didn't need to do anything but stand there and you would win your case. And that has never been
In your lifetime.
in
your
my
professional
lifetime, the court that I've confronted. So it's a
And
complete
Breyer-
And it
whipsaw.
probably won't go that far back.
It won't. don't. And Breyer has been working at this for a very long time. He had an ally in O'Connor for a long time. When she left, he was really morose for about a term or two.
Really?
And then he sort of picked himself up, and Neil Katyal, who clerked for him years ago, said, you know, his clerks used to think he was mad because they would say, you got to be tougher. You got to put in those zingers. You got to be, you know, and when you think they're wrong. And he took the view, remember, he was Teddy Kennedy's chief counsel on the Judiciary Committee. And when I did an obit, I was preparing an obit about Kennedy before he died. I went to, we do that. I went to see him, and I did an interview with him, and he said, you know, he always taught us that you don't, I guess I should say this here, you don't quell when you win.
That's Spanish. Because we're in the east part of New York.
Because there can be, you give credit to others. Because if you give credit to others, it makes everybody, you know, there are lots of fathers of this success. And if you lose, nobody wants to be with you anyway. So and I think he's been at this for a good 10 years.
And that really ripened into something in the abortion case,
Yeah.
where Kennedy made the assignment. He was the senior justice
Right.
in the majority. He could have self-assigned. He could have assigned it to Justice Ginsburg, who'd very much like to have that opinion, but instead it goes to Breyer.
I think that's one of the most interesting decisions of this year, the assignment decision in Whole
Right.
Woman's Health.
And you can see why. Because Breyer, there's no rhetoric. There's almost nothing for us to quote except facts. Just the facts, ma'am. It's just completely, it's a litany of facts. And she writes 3/4 of a page. It has something quotable in it. And clearly, Kennedy didn't want something quotable.
So before we get to some of these individual cases, by the way, before I even get to that, there's a great little Breyer anecdote for folks. Some of you may remember Folks was here, Breyer was here at the Folks Film Festival 2 years ago when we screened The Man Who Shot Liberty Valance. And he wanted to talk about that film. And you reminded me when you said, you know, people were trying to get him to be stronger. Well, let me tell you what he said on stage, and you can go on our website and see him saying this. At one point, he actually recited, you'll love this, Kenji, the Oresteia trilogy. He wanted to talk about Aeschylus and about the revenge dramas in ancient Greece. And then he said, you know, he says, you'll see this on our website, he says, you know, the point of this movie with John Wayne is, and as the gunman, and James Stewart as the lawyer, is that sometimes you just talk too much. You just talk too much, and you sometimes need to bring a gun. Go on our website, it's great. And then he says, well, you know, it took the National Guard to integrate schools. You know, you can have all sorts of lawyers arguing in front of the Supreme Court, but at some point, you have to know when to bring a gun. So he got stronger.
That's richly ironic that he should say some people talk too much.
Yes.
I was waiting.
Well,
That was Adam Liptak making that point.
That was Adam making that point.
one quick question. If Scalia was not on the court, I guess this is an obvious answer, but if Scalia was on the court, and who knows who would have been, Citizen United, Hollingsworth, Hobby Lobby, different? Or those cases, could we, any thought?
President Reagan nominated him. President Reagan was going to fill the seat, right? That seat would have been filled by a conservative. I don't know what brand of conservative.
But President Reagan selected Kennedy.
Right.
But it was his third choice. I mean,
Right.
he had 2 failed nominations.
Right. Well, I actually want to come back to that. I hope we have time. I want to talk about the Judge Bork confirmation before we finish up. But let's get to some of the cases first. Trevor, let's start with you. United States versus Texas, an immigration case. I come to you with this because you served in Obama's Office of Legal Counsel. This case deals with executive actions that Obama had issued that deferred the deportation of 4 million illegal, undocumented immigrants who were here illegally, but their children were here legally. And so it enabled 4 million people who otherwise would have been deported to stay, live, and work in the United States. What happened to that case, and who brought that case? Tell us how it ended up, and without Scalia, what happened?
Sure. So it's an interesting case. It was lots of interesting aspects about it. I'll give you the end first. In some ways, the least consequential thing was its ending. This is one of the cases that is a victim of the court being only an 8-member court, in the sense that the court divided 4-4, and so affirmed the judgment of the lower court, the United States Court of Appeals for the Fifth Circuit, but without issuing any precedential decisions. So the judgment in that case stands, but the issue really remains for the Supreme Court to take up at some future point, potentially, maybe even in that case. So the case was first filed in federal district court in the Southern District of Texas by the state of Texas and 25 other states. Now that by itself is a pretty interesting thing, because it's not straightforwardly obvious how a state is able to challenge the federal government's decisions with respect to how to enforce a federal immigration law. So the theory, Texas's theory for how it could do it, is that this program, this deferred action program, which was really a sort of decision about how to enforce existing immigration law, right? This happens against the backdrop of the either unwillingness or inability of Congress to pass any kind of comprehensive or even not comprehensive immigration reform, despite expressions of preference for that kind of legislative change from many quarters. President Obama and the Obama administration, after having urged that legislative change, sort of as a kind of plan B, announced through the Department of Homeland Security this deferred action, executive action program, which would effectively not enforce the immigration laws by not removing from the country undocumented aliens if they fell within a certain category. It's, as you say, this is by and large people who are the parents of children either born in the United States, who are therefore themselves citizens, or children who are lawful permanent residents in some way, but where the parent is not. There was also an expansion of an earlier program for non-citizens who came to this country when they were younger than 16. That program had been in place in one form since 2012 and was then expanded in 2014. So Texas challenges this, and its theory of why it even had any kind of stake in this, other than an ideological stake, was that this was going to change because Texas just happened to have certain contours in its own laws with respect to things like driver's licenses. This was going to change the eligibility of these undocumented aliens to obtain a Texas driver's license. And this would cost Texas money. And so that was the kind of core theory of standing, and a core theory of sort of how they were injured by this. The substance of their argument, the substance of their legal challenge to the program, was, a lot of it was actually quite arcane. It's the stuff that administrative lawyers focus on. It was first that this program didn't go through what's called the notice and comment process, and this is the way in which an agency, the sort of rules, the process that an agency has to follow when it adopts a new substantive rule interpreting and implementing a statutory program. And it's right that this was announced more as a kind of policy guidance, not put through the notice and comment rulemaking process. The second argument was just that the federal government lacks the authority to do this, that it is effectively contrary to the immigration statutes. And so this was not simply interpreting and implementing the immigration laws, this was effectively rewriting them, something obviously the
What about
executive
the
branch
take
has
care
never
language? Is that
Right.
what that means?
Yeah, well, so there was that argument kind of shades into the last ground, which is turning this statutory non-enforcement argument into a constitutional claim. The argument is that this entails a violation of the president's obligation in Article 2 of the Constitution to take care that the laws are faithfully executed. And so this is, the argument goes, a responsibility to implement the laws, not to change the laws, rewrite them, or ignore them. Now, everyone agrees that there's never been a moment in American history when immigration laws have been fully enforced, in the sense that the government has proceeded against literally everyone who is in the country in violation of the immigration laws. There never really has been a program where the government has attempted to know how many of those people are in the country, let alone to deport all of them. And so part of the government's argument in defense was there always is a kind of immigration version of prosecutorial discretion here. There always is some priority setting that goes on in deciding how to enforce the immigration laws. And what this deferred action program is really just systematizing that, is sort of making clear in a wholesale way rather than a kind of retail way the categories of undocumented aliens against whom the government will bring deportation proceedings and the categories against whom it will not. The argument on the other side is this crossed the line from an interpretive decision to writing in categorical positions with respect to whether people would be deported or not, and that this brought massive consequences, that the people who fell within the category of deferred action here could obtain work authorizations that they couldn't obtain
Yeah,
otherwise.
that's the whole sort of thrust of it, is that when you got a temporary work authorization, which is what this was about, you get it for, I don't remember whether it was 2 years or 3 years, you became, for that period, legal, so
Right.
you were not deportable.
Right.
And other presidents have done that. I think Bush 1 did it for 1.5 million people, but nobody's ever done it for 4 million plus.
Right, and it's the combination of the consequence of the work authorization and the sort of categorical nature of describing a group, all of whom will be eligible for this, that was at the heart of Texas's argument that this entailed a rewriting of the immigration laws. To be clear, Congress could pass legislation achieving this precise end, but Congress did not, and the argument was that this went beyond the executive's authority to exercise some discretion in how to interpret the laws. The district court, the trial court, agreed initially and issued what's called the preliminary injunction
For the whole country.
for the entire country. So one district judge in the Southern District of Texas issued a nationwide injunction prohibiting the federal government, on pain of contempt, from enforcing this deferred action program anywhere in the country.
This guy, I think, is on Trump's list for Supreme Court. I'm sure he's on it.
This is not the first example one would cite of judicial modesty. That is true. But this was, it's very important to emphasize, this was a preliminary injunction. It's the sort of thing judges will sometimes issue at the beginning of a case, pending final resolution of the case, right? Once a trial happens completely, if that's the way it goes, a preliminary injunction might be converted into a permanent injunction. The government appealed at that point, wanted to challenge the preliminary injunction, and the US Court of Appeals for the Fifth Circuit upheld it. Upheld the idea that the states have standing here, found basically 2 substantive grounds on which the Obama administration, that this deferred action program was unlawful. One, that it violated this notice and comment requirement, and the other, that it was just basically a rewriting of the law. And that's what went to the Supreme Court. And the case was argued over the legality of this program, but also over the standing of Texas and these other states to bring suit like this. Somewhat ironically, one of the better precedents for Texas to be able to cite is a case called Massachusetts versus EPA, where the politics really were very flipped. But that was Massachusetts challenging the EPA during the Bush administration for not enforcing aspects of environmental laws as robustly as Massachusetts wanted, and the court found that Massachusetts had standing there. So the standing question was up in front of the court. The nationwide scope of the preliminary injunction actually was not part of the argument to the court, but then the substantive questions were there too. Had the court decided this case either way with an actual resolution, it would have been a blockbuster. It would have been a momentous
So there was
decision.
thought this would have been one of them.
But I think as soon as it was an 8-member court, the risk of 4-4 was extremely high, and this would have been on the top of anyone's list as a case that's probably not going to be resolved by an 8-member court, and indeed, that's
Although
what
there was
happened.
some hope that the Chief Justice who dissented in Massachusetts against EPA and who is a standing hawk
Right.
might be consistent on this point. But in argument, he seemed to show no appetite for that. And I think he's gotten beaten up so much for his 2 Affordable Care Act votes that he was not inclined to save another major Obama program.
Right. I mean, obviously, since it's this 9-word affirmance, we don't know what any of the justices was thinking, but it would have been fair to say that the best shot for the federal government to win would have been to win on standing with the chief as the 5th vote.
Right.
Now, think back, though, if Scalia's on the court, the Obama administration doesn't just suffer this setback of having an injunction left in place, but gets really beaten up in a 100-page reasoned decision.
Right.
So it could have been even worse.
Yeah.
Kenji, how about women's whole health? That's the case. It's also Texas, right?
Yeah, there are 3 big Texas
That's-
cases,
that-
affirmative action cases.
This
Texas
year it was
too.
Texas, a few years ago it was Arizona.
This is the case where they would reduce the number of clinics that performed abortion unless the clinics could demonstrate that they had state-of-the-art facilities, surgical facilities. Oh, no.
Nope.
no. State-of-the-art.
You're not Dahlia Lithwick.
No. Thane, I actually would not describe it that way. I
Really?
would, yeah, the
Oh,
state
she's coming.
the state legislature.
You are Dahlia Lithwick.
She knows how to make an entrance. You know this about Dahlia. All right, say that isn't the way you would describe
No,
this
the
case.
state legislature enacted, it said, in order to protect women's health and safety, regulations that it would have made, that would have forced the closure, and did force the closure of already half the clinics in the state, by making them be sort of quasi-hospitals and not, which would be enormously expensive.
So this is different than state-of-the-art. They have to be.
They have to have 8-foot wide corridors. They have to have one-way traffic within the clinic. They have to have very big operating rooms. These were things that are not required when you go to get your face lifted or a colonoscopy to go to the other end. And, but they were, for this procedure, really only.
But there was another piece to it, too,
And
that the doctors.
And the doctors who performed abortions had to be
admitting
formally
privileges.
have admitting privileges
At
at
local
a hospital within 30 miles. Right.
So-
And most hospitals have a minimum of patients that you have to admit in order, just as the most simple element, in order to get admitting privileges, and hopefully they didn't have 35 patients being admitted.
So she just came in, but this is something that Dahlia and Kenji could work on to speak about. Let's talk about the significance of that case, how it ended up.
Yeah, I do think this is a blockbuster, and to go back to what Adam was saying earlier, just to flesh something out when you said that the assignment, when you talked about the assignment process, the assignment process in the court is that if the chief is in the majority, then he or she will assign the opinion. If the chief is not in the majority, the most senior associate justice will assign the opinion. So in this case, the most senior associate justice was Justice Kennedy, and he assigned the opinion to Breyer. What Justice Breyer did was to evaluate the 2 provisions of HB 2, the law that was just described so ably by Nina, according to the undue burden standard. So the undue burden standard was articulated in 1992 in a case called Planned Parenthood versus Casey, and it replaced Roe v. Wade's standard of saying abortion was a fundamental right with something that was softer. And it said that prior to viability, you cannot place an undue burden on a woman who is seeking an abortion. After viability of the fetus, the state can regulate and even ban abortion so long as there are exceptions created for the life and the health of the pregnant woman. And after a 2008 case called Gonzalez versus Carhart, the health exception may be in question. Right? So what was really interesting about the undue burden test is that my students always say to me, what is the undue burden standard? Is it rational basis, which is basically a very, very permissive standard where essentially if you can show that the statute was written in complete sentences, it passes muster? Or is it strict scrutiny, which is a very, very stringent standard that is often described as strict in theory but fatal in fact? It's generally not that strict, but it gives you a sense of how closely the court is looking at something. Well, it's framed as judicial review or examination. This is a kind of jurisprudence. Strict scrutiny jurisprudence is a jurisprudence in which looks can kill. If something is looked at with the kind of basilisk glare of strict scrutiny, then the statute essentially dies under many doctrinal domains. Or is it intermediate scrutiny, my students ask? Is it some thing that floats in between the two? And my answer is always, it's totally sui generis. You cannot evaluate it according to the traditional kind of tiers of scrutiny. And you just have to look at what the court has upheld and what it has struck down, right? And the previous precedents applying the undue burden standard. So Casey, even though many
This
people...
infuriates our students because they know on the exam we're going to ask them about something that the court hasn't looked at.
Exactly. And I just did that. The Casey opinion is often celebrated as, oh, Roe, we had the court packed with, Reagan appointees who were going to overturn Roe versus Wade, but then Justice O'Connor, Justice Souter, and Justice Kennedy got together and wrote an opinion that said, on stare decisis grounds, we're going to uphold the essence of Roe, right? In other words, even though we might not have decided Roe in the way that it was decided in the first instance, they said, we have to abide by precedent, otherwise we'll look like an overly political court. But the kicker about Casey that I always point out to my students, if you look at the 5 provisions that were in play there, only one of them gets struck down as being an undue burden. That's the spousal notification requirement. So things like a 24-hour waiting period, things like a parental consent requirement for minors with a judicial bypass, other kinds of reporting requirements, informed consent requirements, all get upheld. And that's kind of how we've chugged along, in this area, where in the partial birth abortion case, the Gonzalez case that I referred to earlier, the congressional partial birth abortion statute was upheld as not being an undue burden. And the only other thing that has been struck down, to my knowledge, as an undue burden was a state partial birth abortion plan statute that was much more broadly and vaguely worded. And so if you look at the application of the undue burden test, it's actually a pretty lenient test, right? And hasn't had much teeth, to the point where the litigants, I think, made the mistake, the Texas litigants made the mistake of saying, oh, the undue burden test is essentially rational basis review. And I
We
think
can do
that,
any damn thing we want.
Yeah.
I think, this is one of those cases where you win some for a while and you think you can run the whole
table.
table,
Yep.
and you're wrong. You're dead wrong, and you end up worse off than you were before.
Yeah, and I think that's exactly right. And I think that we have to understand this is very similar to the City of Bernie case, where Congress comes in. The facts of the case are not particularly important, but it gets. Congress essentially says, we think we're co-equal interpreters of the Constitution, and so we like this earlier jurisprudence that you had earlier better than the current precedents that you have, so we want to legislate in those earlier precedents. And the court essentially responds, it's really cute that you think you're a co-equal interpreter of the Constitution, but you're not. We are the supreme arbiters of the Constitution. And I think this was somewhat along those lines, because Bernie was also Bernie was a Kennedy opinion. And I think essentially, even though Kennedy didn't write this opinion, his dander got up, of essentially the litigants from Texas saying this is rational basis, when he was like, no, the undue burden standard was a compromise between the fundamental right articulated in Roe.
But don't forget one little thing that happened. They, at some earlier stage in this litigation, they went up to the Supreme Court for a stay, saying, we're going to be ruined if you don't stay this. And the court didn't grant a stay, and Breyer dissented. And he laid out, he said, half the clinics in the state will be closed in a matter of a couple of years. And Kennedy was on the other side then, and then he watched as 20 clinics closed. This case, they then later did grant a stay vis-a-vis another provision, but it comes back. And now he's got proof positive that it worked that way.
Yeah.
Dahlia?
Dahlia.
Hi. I had a lot of time to think about this at the airport. A couple of things I would just add to what's been said. One thing that's, I think, terrifically important is that Kennedy gives it to Breyer, the least scorching writer on the court's liberal wing. And, you can read that opinion trying to find one soaring sentence, something from Casey, great language that you can, engrave on your napkins, and it's not there. I mean, there's just not one sentence in this opinion. It is a workmanlike, just, I'm looking at the
It's a PowerPoint presentation.
It's as boring, even for Breyer, as it gets, and it's an interesting choice to do that. I think, everybody wants to know where Kennedy's head is, because Kennedy has never found an abortion regulation he can't get behind since Casey. And so what happened? And we don't know. He doesn't write anything. What is interesting, I think, is a brief concurrence by Ruth Bader Ginsburg. And Ginsburg, has for months been writing this opinion in her head. And then she doesn't get to write it. And then she has to watch a PowerPoint unspool. But she just writes this brief concurrence that more or less goes one further than Breyer is willing to go. Breyer says, look, the state's objectives here that purport to be for the health of the mother simply don't map on to what we're seeing. And in fact, you know, and he's very careful, goes through the record. He notes that at oral argument, the Solicitor General of Texas conceded that not one life had ever been saved by the admitting privileges provision. And for Breyer, that's a big gotcha. And he goes through, and even that is not soaring, by the way, but he goes through and he sort of says, this is just workmanlike, you know, I'm not seeing that this is good for women's health, and I don't get it because liposuctions are more dangerous and colonoscopies are more dangerous, and you don't regulate those. And then he's done. It's Ginsburg who pushes it one further in her concurrence that nobody else but Ginsburg signs on to, where she says it is preposterous to believe that this is for women's health. Anything of this sort cannot stand. She's the one who's kind of gunning for the trap laws. You know, she's going the next place. She's not just interested in admitting privileges. She's saying all of it fails. Whatever the test is now, none of it stands.
Also notable, I thought, was that even in dissent, Alito, joined by the Chief Justice, barely defend the laws on the merits. Yeah. They have all kinds of complicated legal arguments about, came up in the earlier litigation, you can't relitigate it, but even they weren't really prepared to say that this is a good faith effort to protect women's health.
But this comes back to Kenji's point, I think, which is that the best defense that would have been available is to argue that effectively undue burden is only rational basis review. And if you're not going to be able to make that argument, because that's just, and it's hard to imagine that Justice
Thomas did say that.
Right.
And said that the Breyer opinion reimagines Casey. Right. You can argue that backwards or forwards.
But since that position didn't prevail, I mean, I regard this as a blockbuster of blockbusters. Since Casey, we had what's been happening to this right is a hollowing out through side constraints. And states, just as Kenji has said, have felt that effectively the limit on their ability to impose side constraints was their imagination. And this case sends a powerful signal in the other direction. I think it's a momentous decision.
There is a little history here, though. You know, I spent a month with Harry Blackmun's papers, and the first vote in the Casey decision went the other way, and it was portrayed as we're not overturning Roe, we're just having a rational basis standard. A rational basis is any justification you give whatsoever. You just have to give one. And that really does take you back to the early days pre-Roe. I mean, you could probably come up with a reason for criminalizing abortion too. So it's 5-4, and Kennedy changes his mind. Basically, after talking to Souter and O'Connor, they come up with what's called the Troika opinion. And they say there has to be, and you have to have in order to strike down a law, you have to show that it imposes substantial obstacles on a woman's ability to get an abortion, an undue burden. Those were O'Connor's words. So the history here is exactly what happened in Texas. It is a rational basis that they're saying. And the Court of Appeals said it would only affect a million women of childbearing age who would have to travel, up between 100 and 300 miles to get an abortion.
2 times, yeah.
2 times.
So, it was that case in reverse.
Yeah.
And the other piece of history that is really interesting, really falls in the category of gossip. All audiences like gossip, and I love gossip, is that when the one provision they struck down in 1993 in the Casey case was the provision that said women had to notify their husband. And then Judge Alito had taken the position that wouldn't affect that many people, that it would only affect a small number of people. And O'Connor's portion of the opinion, the smoke comes out of her ears. And she says, it doesn't really matter how many women it affects. Right. There are women who are being beaten to a pulp who can't tell their husband, and you just need one of those. And it was the reason she never quite warmed to the idea of Alito on the court.
Let's take one more case. There's so many we could talk about. I want to take some questions from the audience. I've got a few other questions before that. I'm gonna pick a case that we might not have picked. I'm not gonna pick Fisher, the affirmative action case, although I think that's an important one. I was thinking about this, is it Strife or Streif? How's it?
Streif, I think.
I'm picking it because I'm actually interested in Sotomayor's dissent. She was a guest of Folks twice for 12 Angry Men and a conversation on her book tour. And she's from the Bronx, which is just over the river. And we've talked about her a number of times. And it's an interesting opinion. Kenji and I have briefly talked about. This is the case where if you have outstanding arrest warrants, say you haven't paid your parking tickets and there's a warrant for your arrest, that alone would be able to cure what might have otherwise been an unlawful police stop, right? So all of a sudden, well, we determined that there's an arrest warrant for you. So what else do you have on you, so to speak? Pretty much everyone joined in on that. And can we talk a little about, maybe Kenji, you could start us off. Sotomayor delivers a kind of unusually written opinion.
Yeah, absolutely. Yeah, so it's a Fourth Amendment case, and as Zane was saying, generally if you engage in an unconstitutional stop, the way in which the court deters those stops under the Constitution is to say any evidence that you procured thereby is excluded, right? It's the so-called exclusionary rule. There are certain exceptions to the exclusionary rule, and one of them is attenuation doctrine, which is to say if there's some kind of intervening event that's a circuit breaker, then you can actually admit the evidence at trial. And in this particular instance, an individual was stopped, and it's uncontroverted that it was an unconstitutional stop. But the officer ran a warrant check on him and discovered that there had been a warrant out for him. And that was deemed to be enough of a circuit breaker that the drugs that he later found on that individual's person were admissible as evidence, or so the court rules. Justice Sotomayor in dissent, where she's partially joined for parts of it, but there's an important part 4 at the very end of the dissent where no one can join her. And the reason no one can join her is that she begins it by saying, drawing on my personal experience. Right.
By the way, this is important, and Trevor really knows this because he prepared her for her conference.
I played a bit role.
That's not what I tell people. You're my boss. He was almost on the court, okay? He was the next one.
Justice Sotomayor could teach us. We didn't need to teach her.
But this is important because President Obama said when he introduced her that she had a very compelling life history.
That's true. Yeah.
And this became hugely controversial. What does a life history have anything to do with it? It's about judicial temperament. It's about her ability to analyze cases. It doesn't matter if she was in a housing project. And so here she says, I think it does matter. And
She actually doesn't say my personal experience.
Professional experience.
She says
Yeah.
my professional experience.
Right.
But then she goes on.
Yeah.
And she is a former prosecutor.
Right, exactly, yeah.
But then she goes on to cite.
Yeah, so I guess let me say a little bit about that, because you're right that she talks about her professional experience, but I think that what everyone has in mind about Sotomayor is the wise Latina comment that she made at the Berkeley speech, and then this was so incendiary. And when I was trying to defend her during her confirmation hearings, and the media would keep bringing up this case, Crimstock versus Kelly, where as a Second Circuit judge, she said, when they impound your car, do they have to give you due process? That was the question. And she said, well, of course you do, because for most New Yorkers, their cars are a primary asset because we all rent, and the car is what you need to get to work. And so, of course you have to give somebody due process before you impound their car. And I was like, well, this is somebody who's clearly, understands what the lives of ordinary working people in New York are like. That's part of her personal experience. Why isn't she allowed to bring that to bear?
But, and in this opinion, she essentially says, similarly, people of color know, right?
Yeah, actually, she specifically says brown and black people.
Yeah, brown and black people know
with their children about how to comport themselves vis-a-vis the police, such as always show where your hands are, never ever talk back. I'm paraphrasing here. But then she goes, and Adam has written a great piece on this in the Times about her dissent. Then she gives what Adam calls a reading list, right, for the general public, where she said, and it's a very Black Lives Matter opinion, where she says, here are some citations, The Souls of Black Folk by Du Bois, right? The Fire Next Time by James Baldwin, and most recently, the National Book Award-winning Ta-Nehisi Coates' Between the World and Me. So you have roughly, right, spaced half a century apart, these three texts right? That she's citing almost as if they're precedents, right? If not a reading list, saying like, you really have to understand that this is not a post-racial society.
And she's reading them the Riot Act about what the experience is of people of color in this country.
And she also brings some data, because you might think that this is a weird one-off case. I mean, how often does it happen that a cop unlawfully stops somebody and there happens to be an arrest warrant out for them? Well, it turns out in some communities, like all the time. In Ferguson, Missouri, 21,000 people, 16,000 outstanding arrest warrants. So this basically gives cops the right to stand on the corner, stop the next person, and have a very good chance at being able to search them, notwithstanding an unconstitutional stop.
And I would just add, one thing that's interesting is that Sotomayor is quite late to the race game at the court. She doesn't talk about it for a long time, I think because she's burned by the Wise Latina comment, and she's, burned at her hearings for being biased, and so she's very careful. And I know we're not going to talk about Fisher, but, a little bit of good gossip around Fisher 1, the precursor to Fisher, is that she wrote this barnstormer of a dissent when it looked like Justice Kennedy was going to strike down affirmative action the first time in Texas, that really, terrified him, and he pulled back the opinion, and then that becomes actually a dissent that she publishes in a Michigan affirmative action case. But she's kind of priming the pump to become the Thurgood Marshall. She's going to be the voice of race at the court, and it took her kind of a long time, and I think this dissent becomes this kind of tour de force where she fully occupies the space, and she's like, let me tell you a little something about Ferguson and how things go there. And it's just interesting because this was not something I think that she wanted to do in her first few years at the court, but she's become increasingly comfortable with the idea that, when Thurgood Marshall would say, here's some stuff you don't know, the other justices, even those who didn't agree, would listen. And I think she's trying to kind of locate herself there.
I have a question, though. Do you think that she let her rip this hard based on my professional experience from the get-go, understanding that nobody would join that part, or that she had some of that in there and other people were very hesitant about joining it, and therefore she let it completely rip?
Yeah, it's fascinating. It's a great question, and I don't have a great answer to it. But I will say that, one of the things that Justice Cardozo says in his essay on law and literature is that dissents are often much more literary than majority opinions, because majority opinions have the force of law, on the parties before the court, as well as, many millions of other people. And so therefore there's always a finger, placed on the mouths of the justices. Whereas when you're in dissent, you've lost the day, and so you can kind of imagine utopia and really let, yourself go, because you don't really care whether people join you or not. So, the person who joined her for the first three parts of that opinion was Justice Ginsburg, right? So the question is, did she write a full opinion and Ginsburg said, tamp this part down, right? Or I won't sign it? Or did she go in and say, look, I just want to speak for myself? And
then my other question is, why didn't she read it? Yeah. Was she just so mad she was afraid that she would?
Because she did read in Michigan.
She read Schuette, right? She read from the bench.
Yeah.
Well, it depended. The decision to read from it's true, it gets picked up by journalists, and therefore it can be reflected out to the
So just to be clear,
broadly.
the justices very rarely read oral dissents from the bench, maybe 2 or 3 times a term. So we pay a lot of attention. We think that it's a sign of really deep, deep disagreement.
But I think that, I don't pretend to know Justice Sotomayor's own philosophy on this, but I do think it's true that different justices have different views about how powerful a signal really is sent by reading their dissents. And sometimes you read dissents and you imagine that the intended audience is somewhat different one to the next. Sometimes a dissenter is chiding his or her colleagues. Sometimes they're writing for Congress to fix a problem. Think of Justice Ginsburg and Ledbetter. Sometimes it's catharsis, or they're writing for history ultimately or something. There's some Justice Scalia dissents along those lines. And this is at once deeply personal passage in this dissent, and it has a reading list. It's educative in a way, and I don't know if she thought that, with all due respect, she needed the media on this way. Right. I think she may think that she is directly accessing.
She didn't, and I personally worry that I was spending too much time on it. and then I read out what all the rest of my colleagues said. And I thought,
I think the last line of that opinion is, until their lives matter too, our system of justice is anything but. So that chimes very closely with Black Lives Matter.
Yeah.
Absolutely.
well, we actually, one of the
She
things
feels
is
like
sort
she's
of-
speaking to those people directly, I mean,
Exactly.
not mediated through.
One of the
media.
things that I
Exactly.
have no way of knowing, and I don't think any of us who cover the court have any way of knowing, is how much for the whole Ferguson business. I hesitate to say the Black Lives Matter movement per se, but the events in Ferguson, the Justice Department report, the numbers of people that we now know are killed for no good reason. And that is, even the stuff about how the courts in Ferguson were making money, using this as a way to fund city operations on the backs of the poorest people. You wonder how much of an effect that has, not only on Sotomayor, but on somebody like Kennedy.
I completely think, I mean, you noted it last year when Kennedy, on the housing discrimination case, sort of like pokes his head up and goes, wait, there's a race problem. For the first time, he's like, what's going on in America? And then, he really kind of doubles down in Fisher. Again, what you don't like, you hate affirmative action. And suddenly, so I actually think I can draw a straight line between, the sort of John Roberts worldview that the way to get beyond race is to get beyond race, and we're all done with that conversation in America. And I think it's very hard to join with that worldview in light of, police brutality in Ferguson and all of that. And I think you can sort of see Kennedy modulating that purely colorblind view that's very doctrinally attractive, but it just doesn't map onto reality.
Trevor, I'm just, I have a few questions before we take some questions from the audience. I just want to know, because you made a face earlier about this, would it be appalling if we left Fisher out? Do you think Fisher, because you now mentioned it a few times, everyone is, I sense that we
Your
should
job's
say,
secure either way.
Yeah, all right. That's what I wanted to hear.
I know that was your question.
And he makes me wait an hour and a half. He could have just said it from the beginning. So is there something we can say briefly about Fisher before I ask one or more two questions, and then we'll take some questions from the audience? This is the second time we've seen Fisher, right? This time we're here for a very different reason, but we have the same result.
Major change of heart on Justice Kennedy's part, somewhere between
And
the Michigan affirmative action cases and
This is the affirmative action case in Texas, where State University would admit 10% of any public high school or private high school as well? Public high school class. And Fisher, Ms. Fisher, is what, 13%? Right. And she doesn't get in, but she makes the argument that I have a higher SAT score or whatever else.
No, she applies under a second part of the program.
Oh, right, that's right.
Which is very much like the way all colleges and universities
Right.
look at
Which
people.
is the
holistic.
Holistic, right.
Holistic review.
And Justice Kennedy, who has never before voted to uphold an affirmative action program, finds that this holistic system, gauzy and impenetrable by design, satisfies strict scrutiny. That basically means race-conscious admissions are here to stay.
I see.
It's very hard to see how they're not.
I think that is true. The opinion, though, also strains to cause university administrators to feel under an ongoing obligation to make sure that they're thinking about race as little as they need to in order to achieve their goals with respect to
he doesn't like it.
race-based diversity. And so he doesn't specify at all exactly what that looks like, but I think there's going to have to be some level of sort of a procedural showing. And
Right.
one can imagine
Yeah.
ongoing litigation.
I bet
whether
there
that
are
is happening.
consultants who will tell you the words you have to say. But I mean, if this program is okay, so this is a program where the top 10 part of it, not challenged in the case, generates very substantial diversity in a race-neutral way, or at least in a race proxy way. And if this...
Because they're segregated,
And if
practically
you
segregated
if you
schools.
make the case that you can layer on top of that a race-conscious system, and that's okay, I think a completely
okay.
holistic
Right. Well,
system has to be okay.
I think that's true, and here I'm with my former boss, Justice Ginsburg, on this one. I mean, so she said, back when the Michigan affirmative action cases were litigated, which was 2002, 2003, the federal government, then the Bush administration, pointed to Texas's 10% plan as a supposedly race-neutral way to achieve diversity. And the idea that a 10% plan, which might be a perfectly good policy, the idea that it is race neutral and therefore sort of not an event at all under the Equal Protection Clause is quite a peculiar idea. So the 10% plan can achieve racial diversity in the University of Texas system because and only because of the continuing reality of de facto race segregation in housing in the state of Texas. And the government of Texas knows that and mandated a 10% plan knowing that and knowing what the outcomes would be. So if this case had gone the other way, you would have this incentive for all universities, not just public, but private too, because the federal statutory law on this would have tracked the same norm, to find ways to achieve diversity in their student body, because I think we're in a world where just not trying to achieve that goal is unthinkable, but to drive it underground as much as possible, to do it with what Justice Ginsburg called winks and nods. And that would have been absurd. And so that we don't have to do that is a very happy day, not just because I'm dean.
All right.
But one thing that I would want to say, I mean, Justice Ginsburg in Fisher 1 says you would have to be an ostrich to think that the 10% program is not racially conscious, right? So that's literally driving it underground. But the idea that the 10% program is racially conscious is something that Justice Kennedy himself raises in the Fisher opinion.
Right.
So he says there's a kind of artificial nature to this litigation because no one has challenged the 10% program. So it's sort of a kiss and a slap at the same time. On the one hand, he's saying, you know, the top 10% program may be racially conscious, but if it is racially conscious, then it may be that someone could challenge the 10% program as being a pretextual, racially conscious program that would draw strict scrutiny.
So
I think that's a concern.
So let me ask one last question. We'll take some questions from the audience. I know, Trevor, you can't be involved in this because you have no credibility with your father-in-law as a betting man. But what do we think is going to happen with that, with the confirmation? Do we expect to see Garland? Do we think it depends entirely on this election? By the way, given the fact the election isn't until November, these things take time. Are we going to spend an entire term with 8 justices? So those are two-part questions. Can we all address that in some way, or just a few of you? What do we expect?
The
Well,
Republicans.
I'd bet 60-40 that Merrick Garland gets confirmed in a lame duck session if Mrs. Clinton is elected. Obviously, if she's not, he's not. If he's not confirmed, and I think there is virtually no chance that President Obama would withdraw his nomination regardless. But if he's not confirmed, if the Republicans continue their point of view that they're not going to do this now after telling us they wanted to know that what the people have to say. Well, if the people elect Hillary Clinton president and they still don't confirm him, I think she, in all likelihood, but not for sure, would not renominate him once she's president, and there would be certainly a younger and probably much more liberal person that she would nominate. Obviously, if Donald Trump's elected president, all bets are off, and all of his lists are only lists. They don't tell you anything.
Anyone else about what do we expect? Any betting people? Trevor, you look like
And
you're
it
ready
is
to
a
offer
full-
one up.
and it is a full
I've got to
year.
bind myself to the mast and not make an actual bet, but I will say, I think Nina's prediction sounds about right, and the likelihood goes up even more of a confirmation in the lame duck if not only Clinton wins the presidency, but the Democrats take the Senate. Then the final act of the Republican majority in the Senate may well be to confirm Merrick Garland.
But if,
It's interesting
if,
that it's only 60-40 because the rational thing for the Republicans to do if Hillary Clinton is elected is to confirm a 63-year-old moderate
Yeah.
rather than to wait
it
for a
is.
45-year-old liberal.
So do you
and
want
yet,
the odds?
and yet the fact that it's 60-40, I'm not disagreeing with the odds,
Oh, okay.
tells you something about the Republican Party.
It's just
Well, the other thing that's worth just observing is that if he's not confirmed, and we have whatever president in January, whether it's Mrs. Clinton or Mr. Trump, they would nominate somebody. There would probably, that wouldn't happen until February. There would be hearings hopefully by the end of March and a vote on the floor in April, maybe early April if you're lucky. That's too late. The court term ends, for all practical purposes, the cases stop being heard at the end of April. So you're talking about another whole term with an 8-justice court.
Yeah.
Which is appalling, right? It's almost as if they're sitting there saying we're so dysfunctional and our solution is to spread our dysfunction to another branch of government.
So,
And I would also add that the court is in this unique situation, right, where at the present time we've had 5 4-4s, we've had whatever Zubik was, work it out. The court is not really high functioning now, and yet you're not reading a lot of op-eds by John Roberts saying, help me. And so the court is in this unbelievable posture where it can't really do its job very well, and with the exception of Justice Ginsburg, who I think was reacting to Justice Breyer a few weeks ago when Justice Breyer was like, we're awesome. We could be 4-4 forever. And I think finally Justice Ginsburg was like, okay, no, we're not okay. But you just don't hear it from the court. And so in a weird way, the court is complicit in this funny nihilism because everybody is saying that the court's fine. And the court is saying, for its own institutional reasons, that the court's fine. And so really, there's nobody saying the thing is broken. And that's one of the reasons it's not in the paper every day.
here's one, I can't resist this question. Did the Democrats make a mistake in the 1980s with the Bork confirmation? Did it set in place this literal political culture of polarization, fractiousness, mean-spiritedness? Bork, for those who remember, he was a judge on the DC Circuit. He'd been a Yale law professor. He appeared to be qualified. And is this the response that came from that?
Well, the Republicans would like you to think it is. And in some ways, the Democrats or the groups associated with Democrats did things that hadn't been done before. They had TV ads. They had, protests outside, those kind of things.
That had never happened.
I don't think it happened, no, I don't think it did happen that way.
There were moments much earlier in the court's history where there was all kinds of political heat around nominations.
Right, but
Like
they didn't have-
like Abe Fortas?
Well, no, way
earlier.
But then, at that point, they didn't have hearings.
That's right.
So in this case, they had hearings, and Judge Bork was questioned for 5 days. 5 days on the witness stand. He refused to do any trial runs with the White House people, what are called murder boards, which is what my friend here on the right did with Justice Sotomayor. He was one of the murder boardians, and or murderers, or whatever. And so he didn't have any of that, and he was not a great witness. And by the time, when those hearings started, you couldn't have gotten a bet around Washington that said he was going to be defeated. And by the end of those hearings, I think there were 7 or 8 Republicans who voted against him, too. It was a very heavy vote against him, 57, 58 votes against him. And so, and I would lay that at least partially at the feet of the nominee. I mean, what was the famous thing that it was Hatch who threw them his softball, said, why do you want to be on the court?
And he said it would be an intellectual feast.
I've never understood why that was such a bad answer. It's true.
Well,
It's a little.
Not allowed to say it, but let me say one thing.
You should
Let's.
not be a nominee to
Right.
the Supreme Court.
Probably
No
the
worries.
Supreme Court doesn't exist for the intellectual sort of stimulation of its members. It exists for the country.
But let's assume the Democrats bear some blame for setting up a culture of whatever. Consider the alternative. If the person who got that seat was Anthony Kennedy, the America we live in over the past 30 years would be a very, very different place if Bork goes on the court.
And in a way, that might be the legacy of the Bork hearings, because it's only after Bork goes down and then Douglas Ginsburg goes down that we get Justice Kennedy. So the luxury that we have over, as a liberal, fighting over Kennedy's vote and whether we're going to get Kennedy's vote, we would not even have that luxury if Bork had actually gotten confirmed.
And it's
so that's an object lesson to the country about how long-lived these justices can be on the court and how they can totally change the complexion of the country, which is why Merrick Garland is being blocked right now.
And I think it just needs to be said that this isn't just Merrick Garland. This is something that is leached into the circuit courts, it's leached into the district courts, it's leached into every position that needs a hearing. And so it's, this is not just about Garland. This is about, a deep-seated policy of obstruction that is now, spread out right down to levels. I mean, it is, paying dysfunction forward down into the rest of the court system.
And I also think, it's literally impossible to know, but had Bork been confirmed, we'd know the court would be different. We don't have Justice Kennedy in that sense, or he would have to come to the court by some other path that's very hard to imagine. But the idea that we should assume that we would have then kept a judicial confirmation process that was largely apolitical and not fractious seems to me another rather large leap. And it's hard to identify exactly when it would have happened and with whom, and of course it would have been a different court that the country was reacting to that had a Justice Bork on it. But I think it's close to inevitable that we would have ended up with some deep political gridlock over the court if we were going to have deep political gridlock in the rest of our government.
Right. That's right.
And that's where we are.
One question from the audience, and then we'll say goodnight and thank our guests. It's something that I alluded to in the beginning. So Justice Sotomayor changed her mind about allowing cameras in the courtroom. The four of you, the five of you on stage, you're in the business of getting great seats. You're at the oral argument. Actually, the three of you, for those who cover the court, you're in a privileged position to see it. When I had Sotomayor on stage here, she just said, I don't think people would understand it. It would only confuse them more. That's not what she said initially, even when during her confirmation hearing, she stated.
It's a deeply patronizing statement to say, you Americans may not see your government at work because you're too stupid.
And wasn't Scalia's formulation of that even worse? His formulation was, well, they don't sell law reviews at the 7-Eleven, right? So, it was...
All right, that's worse.
I just want to put out there that, there's different ways to say people are stupid, and that's like at the apex.
So nobody... So nobody here thinks that this policy of no transparency when it comes to oral arguments is a good one. Everybody thinks we would all be better off.
We all have a self-interest. We're better off because you have to rely on us.
Yeah, we all have a self-interest, and I could make the argument that, radio would be better than TV. But there is at least one argument for that, and I put this forward very seriously, and justices, when you ask them about it, they say, oh, no, that's not the reason. But if you put them on television, they would suddenly have to have a security apparatus, perhaps not like the president's, but you would not see Elena Kagan feeling melons at the supermarket. You would not see justices driving themselves, ever, any place. They would, if you think they're in an ivory tower now, they would be in an ivory cocoon then. And I think that's really not a good idea.
But that might be right. It's interesting then that the Justice Thane asked about this, who changed her mind, is the justice who is by far the most easily recognizable one across the country right now.
Right.
She can't, I don't think you can turn that up. She's already at 10, she's at 11. She's...
No, I don't, I think that actually it goes down after, you forget. You're on television every day for a couple
They don't
months.
seem to be allergic to going on television to sell their books.
Yeah. And then she goes out and she sells her book, and that's now finally subsided a bit. And I'm not saying that she wouldn't be recognized, but I have had the experience, crazy as it may sound, of sitting with a Supreme Court justice at a movie and having people notice me before they notice them. And I'm not talking about Steve Breyer.
Well, we know Breyer likes movies.
Yeah, but he looks like a lot of other guys.
Yes,
The women tend to be a little more.
So before we say goodnight, and this was a wonderful night, but before we say goodnight, if you're getting CLE credit, you have to check out before you do in order to get it. Stay tuned on our website for the Folks Film Festival that's coming up. There are so many amazing guests, I'm afraid to tell you how many there are. There's just some really great guests. We have Cory Booker will be here for our conversation series. We're starting a whole new program next year, a co-produced program that will have Paul Giamatti and David Strathern reading for a program called Theater of Law, in which they're going to do public readings from Kafka's The Trial. And they're going to do public readings from
A real upper.
from Eumenides, from Eumenides, Aeschylus's Oresteia trilogy. We have a number of things happening next year, so stick with us. But for now, this was a really incredibly successful launch for Law of the Land. We want to thank Dahlia Lithwick and Adam Leptak and Kenji Yoshino and Trevor Morrison and, of course, Nina Totenberg.